My lord, may I permitted to mention? My lord, it's contempt application. Order was passed on 11/12/2024. My lord, petitioner
It's on the list.
in the list, monthly list 198, upgradation. My lord, petitioner is specially able person and he is going to retire in December 2025, in this year only, my lord.
What is the due?
Promotion and promotional benefit.
Yes, you wait. Yes.
My lord,
Yes.
my lords, may be permitted to mention one matter, my lord. My lord, in this matter, my lords, heard this matter. This is regarding the pensionary benefit to the minor child. The minor child from the second wife, my lords, heard this matter. The returnable date, I am the minor son, my lord, 3 years of age. The returnable date was, my lord, 3rd of December 2024, my lord. This matter is now running in the item number 324 of monthly list. Last week it was on 138, probably, my lord. My lord, I'm waiting since December. I'm out of everything, my lord. I don't have anything, my lord. I'm
Next week.
next.
Monday. Upgrade.
I'm so grateful, my lord. Grateful, my lord. Grateful.
My
My lord, in the meantime, I will serve a notice to the other side.
Please do so.
Grateful, my lord. Grateful.
This matter, my lord.
Next. Call the list.
Grateful.
Item number 1, 2, and 3.
I'm appealing for the 1.
Your Lordship, item number 3, which had been tagged on the last occasion, Your Lordship, Miss Sinha is appearing on behalf of the state. He had indicated that she's out of station. The matter may be taken up tomorrow if Your Lordship pleases. So, it was mentioned on Friday. This was indicated that she won't be available today. This is a tagged matter, the recalling application, Your Lordship.
The calling of which order?
Lordship, I am not briefed. She
Oh,
indicated
that other rate
that-
is dependent upon
yes,
this.
yes, Your Lordship.
That matter.
That may be taken up today, tomorrow, Your Lordship.
First matter, Mr. Mukherjee is also
If
there.
that is so, I have no objection, but item number 3 may be taken up tomorrow.
Your Lordship already decided the issue following Nimaicha.
No, we have already said that it should be.
And only ground has been taken in the recalling application. The affidavit direction was not there. But in the tribunal, there was a direction. They have filed a opposition. They have taken the same plea as in the opposition recalling. So therefore, I cannot.
Let us see.
I am a little handicapped. I mean,
It is for them to argue the
Yes.
recalling
Yes,
application.
my lord, kindly make it
Gratefully.
not today.
Not today only.
not today, not
Be on the same position.
Yes.
So that it can be hard.
Yes.
yes, Your Lord.
Yes.
Gratefully, Your Lordship.
No, Mr. Mukherjee, we have already held in the order, last order, that after the recall, we will take it up. So let it, tomorrow both of you can,
Yes, yes. Can be done.
if both matters are to be taken up tomorrow.
Get. Right.
Item number 4.
Lordship, this is the matter where your lordships had directed the petitioner to produce a copy of Rule 31, where the lordship
Have you served on the advocate there?
my advocate on record, she has, when she's in court, the 8th lordship, she's just on her way. Because it was a direct, I believe, but the proof of service is not with me. The service will get it. Advocate के service will get it.
Yes, directed that issue.
Lordship, a mail has been sent. Mail, it has been sent. Sure. Sent by mail. Lordship, it has been sent by mail, Lordship.
Why? When you have to serve on a lawyer, you send by mail.
Directly. Oh,
Lordship, I am appearing in item number 1. May I be permitted to give my appearance, Lordship,
Item number 1.
for the principal account engineer?
after this.
Lordship.
ওটা direct
When you have to serve on a lawyer, why should you send it by
Exactly.
post?
ওটাকে directly করার কথা ছিল। Then Lordship will kindly
Service is not
by hand করে দাও। ক্যাটে যেতে হবে কারণ তাহলে advocate deeply affects.
Item number 5.
I am for the fixation. I am for the fixation. Appearance fixation.
yes.
I argument is over, my lord.
Where is your counterpart today?
কি করে বলবো সেটা?
How will we consider now that it has become so voluminous? How do you expect that we will consider everything? This paper book is now useless. And pointless. Anything else is to be filed by anyone?
No.
We don't have it. Yeah. It will require some time. So we are going to add
So far as my argument is over, documents which has been given, just the rules and everything. My lord has followed it earlier occasion. Let my counterpart come and say, my lord, because of this thing, my lord, some time has passed. My lord, person is suffering. I am in press.
obviously
I am.
We are ourselves grappling
No,
with this matter.
That's true. My lord has.
So many dates we have tried
Yes,
to
yes,
conclude
yes,
the
that's
matter.
true, my lord.
Some reason or
I
the
bow
other.
down to your lordship. My lord, only
So therefore, we are saying that we'll keep it at 2 p.m. so that it can be finished tomorrow.
Tomorrow.
Yes, we are just adjourning it, not today.
Yes.
You inform the other side also.
Yes.
Tomorrow it will come with 2 p.m.
Yes.
so that it can be,
Yes, yes.
you will have sufficient time. It can be. No orders tomorrow. Just inform, please inform the,
Clerk said that he's coming. I just
inform. Because if we take this up right now, then everybody will have to keep waiting. If we take it up 2 p.m., then it can be considered. And Mr. Counsel, if your other side has any problem tomorrow, then please inform us.
Item number 13.
Item number 13, my lord, I am appearing for the. Have given notice.
Refixation.
This is a case, my lord, where we have been granted the MACP, my lord, that is Modified Career Advancement Program. And my lord, after my lord, lapse of my lord, 8-9 years, my lord, it was suddenly, my lord, withdrawn. Lord, the case of the operative was that, my lord, pursuant to an my lord, data has been, my lord, issued by, my lord, the department, stating that the upgradation which has been my lord, taken by the railway board should be treated as a promotion. And as it is a promotional post, my lord, MICP is not allowed promotion, persons who has been promoted. But it is a in lieu of promotion.
What has been treated as a promotion?
My lord, upgraded.
Prior to grant of this MSCP benefit, you were given an your post was upgraded.
Our post has been upgraded. All of us, my lord, in block upgraded. My lord, these, my lord, case came up before my lord, or honorable, my lord, before the last tribunal, my lord, in the principal bench. In the principal bench, my lord, it has been decided in our favor. My lord, that was probably, my lord, not placed before the, my lord, learned tribunal at that time, because that was prior. My lord, in 2016 it was decided in our favor. My lord, the same case, the same, my lord,
The same upgradation has been held to be not coming in the way of grant of MSCP.
Yes, that is there. And my lord, that, my lord, against that, my lord, an appeal has been preferred before the honorable, my lord, division bench of the Delhi High Court. But Delhi High Court, my lord, also, my lord, pleased to uphold that no, it is a upgradation, it is not a promotion. So these cannot be treated as a promotion. My lord, all these documents, my lord, was not considered.
Delhi High Court judgment has not been challenged by the Union of India.
A review has been filed. Review has already been ordered. Another, my lord, the review was also discussed. But here, my lord,
No, they have not gone before the apex court in this matter.
my lord, that is not, my lord, their case because of this reason, my lord. I have filed 7 matters, my lord, before this, my lord, learned Central Administrative Tribunal, my lord, which has been decided in February this month. My lord, February this year. My lord, pursuant to the decision, my lord, they have also carried out the decision of the tribunal granting us it to be arbitration in terms of the my lord, judgment and my lord, giving us all the benefits.
So this is the only exception.
This is the my lord case in 2018, my lord. Some persons went and that was dismissed.
So what you are saying that principal bench has decided the issue as you want it to be. Other 7 cases, this bench also has decided, but in this case,
my lord, landed, Central Administrative Tribunal.
so this bench which has passed the order impugned, and in your case there is a different order.
No. In my lord, this is a change before my lord. I was not there, my lord, before the tribunal. In 2018, it was dismissed. It was my lord challenged in 2009 before this honorable court. But the matter is pending, my lord, till date.
No. So therefore, we are saying the Central Administrative Tribunal Calcutta bench
Yes.
decided 8 cases. 7 have been decided as per the Delhi High Court judgment, and one which we are considering has been decided contrary. This is your submission. So where are those 7 cases?
That is.
And do you know whether they have implemented the order of the Delhi High Court or these 7 cases in favor of
Yes,
the?
my lord. Here, my lord, I appeared. My lord, in this case, my lord, I didn't appear. In these 7 cases, my lord, I appeared before the London Tribunal, and I have got the my lord, from my plans, my lord, it has been just implemented.
The judgment of the tribunal has been implemented.
My lord, I am giving both the copies. But this is the tribunal's order, which has been passed. This is the my lord, pay fixation in terms of the order.
Then what remains? The tribunal has held that the earlier order is per infurium. See page 9 of the order. 1239 of 2017, page 9. You have it. Thus, the orders of the principal bench. See the paragraph at page 9.
Lord, that is the main thrust of the matter, my lord. That was probably, my lord, not before the tribunal at the time.
Sir, please read it till the end of that page. The tribunal has already held its earlier order to be per inquiry. And they have not challenged this order. You are saying they have implemented it.
My lord, I have given. Our cases they have implemented.
No, in these cases.
In these cases.
Who appears for the Union of India.
I have given a notice, my lord. Probably, my lord, cannot contact him over phone, my lord, today. If my lord, once, my lord, I will give another notice, my lord, Saurabh, I have given the notice prior to
Railway. Who is the other? Railway. It is railway. Who is the other side?
there is, my lord, he appeared, my lord.
What is his name?
Saurabh Mundal.
Gaurav Mandal.
I have given the letter, my lord, he has received it. My lord, on 15th of July, it is, my lord, long before, but thereafter I cannot, that the file was not listed. But let me give another notice, my lord.
Ensure you.
But the matter will be fixed on Wednesday, day after tomorrow.
Day after tomorrow, my lord.
In the meantime, you intimate the learned counsel.
You were not here. We had taken it up. See, we are now with the records have become very difficult for us, and the paper book is practically pointless now. So we thought it proper that we'll have it at 2 p.m. So not today, we have kept it not today, tomorrow at 2 p.m.
My lord, I have a personal difficulty tomorrow and day after. If it would please my lords, if this matter could be kept on Thursday, I would be grateful. Or my lord, if my lord can give me a time today, I can start today and then complete it.
We would like to start and finish. That's why we said at 2
My
p.m. we'll keep it. Otherwise, it is being adjourned repeatedly for
My
some
lord.
reason or the other. So where is your counterpart?
He was sitting outside, my lord. I told him to come inside
So you
because
please, you will be here. Come at one before at the time of recess. We'll
My
fix
lord,
it in his presence.
I'm grateful. I'm grateful.
Item number 14,
14 is also the same matter, my lord. 13 and 14. Same matter.
Same order or same lawyer is appearing in both the matters for union of.
Same counsel is appearing. Any.
Start shouting.
item number 15,
15, my lord, I'm appealing for the respondent.
Yes, my lord, I appear under the.
My lord, before my learned senior friend starts, respondent number 8, my lord.
Lord, may I submit one thing?
Something or something.
Lord, may I submit one thing, Lord?
Lord,
I just now I have been informed that respondent number 8 has expired. So
respond. You are for?
I'm for the appellant, Lord.
Appellant means Union of India.
Union of India. Lord, let him supply the.
No, Lord, I was speaking to one of the clients out of 9 is present in court. I was just asking him whether they were aware of the legal heirs.
Yes, yes, that is.
My lord, they were his colleagues. My lord, after his death, his phone is not ringing. My lord, they have tried to contact. Now, my lord, in this event, my lord, only thing, my lord, I can say is, my lord, I can try with my client to get the name of the legal heir.
Next week, Era,
I mean, that's not sure.
so that I can get the particulars, I can file the applications.
You are the employer.
With a service record, he might have the name of the wife.
I know because Milord, when Milord it is a court proceeding for such reason we are getting some records. Ultimately, it has come to our knowledge that he has expired because Milord, the service has been returned with a note that yes, deceased. Now, Milord, we are to inquire about that.
He intends he can assist you, but from this end we cannot impress upon him.
No, my lord, had it been a case, my lord, he was our
What
relative.
is your
grievance with the order? First tell us.
Milord, the grievance with the order is Milord, they were initially they were appointed as a peon in the Milord, postal department.
When did they become postal assistant?
Yes, Milord, 2008.
2008. Well, 1995.
1995.
1995.
First peon 1995, postal assistant 2008.
Lord, 1990, Milord, they became postman. Thereafter, Milord, on Milord examination, crossing through examination, Milord, they became
Departmental examination.
in 1995, they became postal assistant.
Postal assistant in 95.
95.
Where is that order?
Lord, my Lord will find that kindly turns to page 59. Twentieth of January, 1995.
Okay, first paragraph, fourth line.
আচ্ছা কোথায় আছে এটা page 8 ও এমএসসিপি টা ইন্ট্রোডিউস করেছেন So why is it that you don't want to recognize this as their date of entry in the service? That is the only issue. Why is it? Tell us.
But they in the year 1st September 2008, first MSCP was given effect to in respect of them, and thereafter, my lord, by
What
way
has
of,
the tribunal directed?
my lord,
What has the tribunal directed you to do?
my lord, give the benefits to them. My lord, the issue remains, if your lordship can
Tribunal has not directed to give the benefits.
page 6.
That is not the direction of the tribunal.
Absolutely, bow down.
Therefore, we are asking you, what is your grievance? Tribunal has not directed to give them from any date.
Yes, my lord. The respondents are directed to place the claim of applicants for examination afresh before the review screening committee treating the date of entry into the cadre grade of the postal assistant as the starting point of the release and financial the first, second and third MSCP as the case may be to which they are entitled. Keeping in mind that the promotion of the applicants of postal assistant was not a promotion within a period of 3 months from the date of receipt of a certified copy of this order of the consequence. Simple. Now, my lord, if your lordship kindly sees the page 68, my lord, what is the MSCP scheme?
So what is wrong in the order? First show us. Why should we go in the scheme?
I have followed your lordship's view
Then-
that you have to review the same. Thereafter, you are to pass the reasoned order.
So why are you here? That is what we are trying to ascertain.
I understood, your lordship. Then I shall not.
Is it that you don't recognize this 20th January 95 order?
No, I cannot.
Then what is it? They say that taking this as their date of entry as a postal assistant, you do whatever is required in
My lord,
terms of the MSCP.
Subject to your lordship's kind sanction, my lord. I cannot say before your lordship that I want to withdraw this petition, but I have to take the instruction. I need 2 days only.
All
So
right.
that yes, so
Let's
that
have
will
a
be better.
discussion, see what they say.
Yes.
If there is any point that you want to press, then
Then,
we'll
my lord,
see
I-
about
I-
substitution and all.
Day after tomorrow.
As paid by learned.
Item number 16.
My lord, item 16, my lord, Mr. Sudipta Panda appearing for the petitioner, my lord. This is a change brief, my lord. He has got, my lord, for some reason, my lord. See, he needs some instruction, more instruction. For that reason, I'm paying for fortnight time, my lord. And my lord, he is also suffering for a viral fever, my lord.
2013 matter, sorry sir.
My lord, it's a change brief, my lord. I have been instructed by him, my lord.
You should not have taken unless you had the instruction. If you have taken, you must proceed.
My lord,
No adjournment, sir. No adjournment.
Sir, I am
We
not
are very sorry. Either you proceed or we'll record that you don't want to proceed.
my lord, I should be candid to you.
Sorry, we have already expressed. This is not the way. Every day a new lawyer will come and then an adjournment has to be granted. This is not the way. Huh? It is.
But I am not engaged in this matter, my lord.
Can you please don't appear? We'll record that none appears and we'll dismiss it in default.
Lord, may I make one humble submission before your lordship, my lord? May I make one humble submission, my lord? My lord, kindly make it pass over, my lord, in that case.
You start, tell whoever has to come that he should come. Yes,
But I should not make further,
there are two issues. Yes,
I should not make further submission before your lordship, my lord, because I am, and I'm,
then you please, you should not be here.
yes, my lord, I take
Can be
your
done.
lordship's leave, my lord.
Yes, we'll record that there is none to represent the writ
Sir,
petitioner.
I don't know anything about this matter.
Huh?
I don't know anything about this matter.
Then why did you come?
I have been instructed by that is the reason.
If he is not interested, let him stay where he is. Yes, you are for? You are appearing. We'll record that. This is going to disappear. Yes,
So Udav Mondal is appearing on behalf of the Union of India, and Mr. Mondal releasing from this matter, man.
Mr. Mandal,
Retire from this matter. From this matter. He intimating to the Union of India.
you are not that much required. It is applicant to be required. They are the red petitioner. They are the red petitioner. It is nothing in the matter. He is claiming stepping up. That's stepping up. The big senior person. He is not an external senior. Mr. Make him to show that. Well, I said there is nothing. Yes, Hey. The day has come before us. When it will come. Going with us. First.
Item number 17.
My lord, beg to appear for the appellant herein.
Yes, you please proceed.
And I have prayed for release of financial benefits and regularization on and from the period of 7th September 2000 to 30th September 2002. Now, this
2002
2000 to 2002, there has been several rounds of litigation.
for 2 years only.
Yes, for those 2 years. I have been superannuated in the year 2011. Now, my lord, in those 2 years, what had happened? My wife was diagnosed with cancer. So there was a transfer order that was upon me. I had challenged that transfer order. There was several rounds of litigations, representations, deliberations by and between the employer and the employee. Subsequent thereto, my lord, due to no fault of mine, this two period, my lord, this 2 years.
No fault of yours.
Absolutely, because I had been to the competent authority of law, to the authority, to the employer, to each and everyone. My lord, there are
So what are they expected to do? You tell us.
Well, they had transferred me to a remote place. I had challenged. Kindly takes up.
All right, we have understood. You were placed under transfer. You did not want to go. You said there is a difficulty because your wife is undergoing treatment.
Yes.
2 years you did not comply with the transfer order.
No, I had. Subsequently, by an order of the court, I had joined.
Yes. But then you joined, you did not, you were not attending the office.
No,
So for that 2 years, there is a leave or there is an absence. How it can be regularized? You tell us. Under which provision?
Well, it kindly takes up the first order, that is at a second.
It is to be regularized under which provision? You are before a court of law.
Well,
Either there is a provision under which you can be granted a relief or there is no provision. They don't have any leave in their pocket that they can take it out and give it to you. It has to arise from your own leave account. And there is a limit to that, you know very well. If you are an employee, once you have exhausted that limit, how it is to be regularized? At best, without pay, without treating it as a break of service. That is at best what you can get. Have they treated it as break in service?
The difficulty is that, I had a junior malad in this.
No. Just look at the order. Forget about that. So what matters, there's no question of any adjournments. We could have understood that they have precipitated some action, treated it as break in service, proceeded against you, then there may be an occasion to say that, look, this was a difficulty, I have no option, I will suffer for non-payment of salary, but I should not be proceeded against. That's not your case. You say I had valid reasons for not attending the office. You may have. So it is to be regularized under which provision? You tell us. The tribunal says there is no provision under which it can be done. So what is wrong with the tribunal?
Whatever is falling from your lordship is absolutely correct. May I just have a day's accommodation so that I can come back? I had a talk with let me have a talk with the client because his junior is assisting me in this matter.
Not today at best, nothing more.
Absolutely,
Yes.
because only this thing I need to convey to the client.
Tomorrow it will be taken up. Tomorrow it will be taken up. He is not listening. Tomorrow this will be taken up. So this will be taken up. Why this man every now and then comes?
40 साल पहले का है, हमारा उम्र मरने का आ गया, मौत सबका निश्चित है, हमारा सुनवाई किया जाए, क्लोज कीजिए।
आपका कागज देखिए।
एक कागज हमारा दे दीजिएगा, फिर देखिए 11 मार्च का ऑर्डर हुआ है, हमारा मेडिकल देखिए पढ़िए, अभी उम्र हो गया मौत का आने, बाल बच्चा का आपका जय जयकार रहेगा। देखिए आउट ऑफ माइंड मेडिकल ग्राउंड अथॉरिटी, हमारा मेडिकल बोर्ड हो गया है, फिर रिव्यू भी हुआ है, असर आपके कृपा से हमारा रुका हुआ है। सब दे दिए हैं आपको, उसी पर डिस्पोजल लिखिए ना, क्लोज लिख दीजिए 11 मार्च के ऑर्डर को। मेडिकल बोर्ड प्रेसिडेंट आउट ऑफ माइंड मेडिकल बोर्ड बोले सेवा में हमसे, भारत सरकार के सेवा में है, हमको क्लोज करवा दीजिए, आएगा समय में आ जाए, मर जाएंगे, अब मौत आ गया है हमारा नजदीक, देखिए बाल सफेद हो गया, कुछ कृपा कीजिए हमारे ऊपर, क्लोज करवा दीजिए हमारा मकान। 11 मार्च को दे दिए हैं साहब, हमको दे दिए हैं।
आपका एडवोकेट कहाँ है?
हमारा आप ये दूसरा वो ये धोखट सब पैसा खाने वाला खा गया, 10,000 20,000 30,000 रास्ते पर फुटपाथ पर खड़ा रहता है साहब, पैसा खाने के लिए। नंबर लिखिए, कार्ड लीजिए।
It is 26 of 25. How did I?
Your Lordship, I've been pleased to direct the matter to appear tomorrow. Could it be day after tomorrow? I have a personal difficulty, on medical grounds, but nothing more. I just recollected it now. Just day after tomorrow.
Will come with a note, not today. Tomorrow that matter will come with a note, not.
But it will day after tomorrow.
Yeah, understood.
Madam.
Understood it.
For sure.
It is not today, Calcutta.
Item number 18. Made resolution.
He is having some personal problems. Therefore, he wants to come. My lord, can he have? My lord.
Proceed. Let us see. Impugned order is 28/7/2015.
Fine.
What is the issue?
Because the impugned order is at 28 July 2015.
Yes.
So the issues boil down. The extent, my lord, that there has been an original order passed by the tribunal directing, my lord, the railway administration to treat my service, my lord, as regular. Since, my lord, the tribunal held that there had been no occasion that I did not, my lord, go to join the duty. It was for the railways authority who prevented me. And, my lord, with the consequential directions, my lord, the tribunal had directed the railway authority. Kindly comes to, my lord, page 22 first. Before going to the order impugned, my lord, kindly comes to page 40. I stand corrected. No. No, I'm sorry. Page 22. Kindly comes to paragraph 7. The first order passed in OA.
So this was an OA earlier filed by you.
Yes. And that attained finality. Subject to corrections, my lord, your lordships have heard this matter previously. Kindly, my lord, take from paragraph 7 onwards, my lord, may I read? It is also seen that the applicant offered to resume duty. Have you lordship got, my lord?
No, resume means he was away for how long?
He was there. Well, he was on a leave for a few days.
Few
But,
days, few months, few years. Tell us.
Well, on a medical ground, my lord.
Period we are asking you. The ground will come later. What is the period of absence?
That your lordship would find, my lord, here in the paragraph itself. My lord, kindly read, my lord.
7.
7. It is also seen that the applicant offered to resume duty after obtaining treatment for his sickness, which prayer was apparently not allowed on flimsy ground that he was treated by some private medical practitioner. Not allowing one to resume duty amounts to termination of service. But such termination is bound to be treated as honest when it is an outcome of violation of principle of natural justice codified in the statute book as extracted in para 4 and discussed in para 6 above. In one hand, the railways state that the applicant had no temporary status, and on the other hand, they expected him to visit the railway doctor. This is like blowing hot and cold in one mouth. There are no reasons to disbelieve the certificate obtained from a private medical practitioner. The authority ought to have, if in doubt, sent the applicant to a medical board. Without doing so, they should not have ignored him. When it is the case of the respondent that the applicant remained absent from 29/1989 and he placed materials, medical certificate from a private medical practitioner to show that he was under medical treatment from his sickness from 90 and 95. His name was in the role of substitute to be engaged as and when the regular hand remains absent. It has not been pointed out by the respondent that between 89 and 90, they have offered any job to be discharged as a substitute to the applicant, which he failed to do being absent. At last, no order offering duty to be discharged as substitute has been produced before us, nor it was pointed to the applicant even in the show cause notice. Without offering any engagement to be done as a substitute, the respondents cannot at the distant point of time take the plea that the man remained absent if it may be that the man in control of the matter might not have given substitute job to the applicant and yet taken the plea of absence. Thus, the plea of absence in the circumstances cannot be a ground to terminate the service. Having held that the applicant acquired temporary service on completion of more than 120 days of service as hot waterman during 87 and 88, even before engaged as a substitute in March 1989, and that the action of the railways pertaining to striking of the name of the applicant from the rolls to be bad and honest, and now stands quashed. Now we proceed to examine the grievance of the applicant pertaining to regularization. It is the case of the railways that the applicant was repeatedly called while his name was still on the rolls to face as the screening test to be regularized to be absorbed in regular establishment. It is the positive case of the applicant that no such notices was ever received by him. The respondents have placed no materials on record to substantiate their stand. Therefore, the respondent should now give a fresh opportunity to the applicant to face the screening for being regularized. As a consequence, it is held that the applicant acquired a temporary status under the railways before engaged as a substitute and that his name continued to be on the rolls of substitute for which he should now be given engagement as a substitute, and that now he should be called for a screening test before being regularized. The entire exercise is to be called on such and such. Now, after this order, my lord, which attained finality, ওদের orderটা দেখা, ওদের ওই orderটা দেখা।
So your status as a substitute.
And they regularized, but they ignored this tribunal's order. They again
After this, they have considered you and regularized you.
yes, but from the date when the order was passed. And the tribunal said in the second round of litigation that I do not find any such order in the previous litigation.
No, even if we were to read this order into the letter order, how does it antedate your regularization?
No. So far the benefits are concerned, they treated me as joining from the date of passing the order.
Correct.
Kindly
So
come-
as a result, that's why we are asking you. You said that this order was never challenged.
No.
So this order is now binding inter parties.
Fine.
Both you and the railways are bound by this order.
Lordship.
So what is there in this order which allows you to claim the benefit retrospectively?
My lord, my lord, so far as my joining is there, that treated from 13/3/2000. My lord, my joining is from 1987, 4th May 1987. They treated me as joined from 13 March 2007. This is their own record.
Your status after the regularization has changed. Regularization has taken place in 2007. Now, why the regularization should operate retrospectively, that we are asking. Your grievance is that they have made it prospective from the
my
date of the order.
They have changed my date of appointment itself. The date of appointment was.
Where is the order of regularization?
Yes.
There's no question of any change in the date of appointment. The question is whether you are to be given the benefit of regularization with retrospectivity or not.
My lord, kindly comes to page 38.
The order of regularization.
No. Kindly see, my lord, my date of appointment. It says, my lord,
That was a substitute as and when work exists. That was as a substitute as and when work exists. Maybe work will not be there for 6 months, you will get it after 6 months. So that entire period is to be taken.
no, my lord, so far the tribunal also, my lord, order is that so far as my benefit.
Come to paragraph 9 of the earlier order.
Yes.
You acquired a temporary status and your name continues to be there in the rolls as a substitute.
Yes.
Now, based on this, they say you should be considered for regularization. You have been regularized and admittedly from the date of regularization, you have been given the benefits due. Why it should have any retrospectivity, that is the issue. What is the basis of your claim? That's what we are asking you. Where is the order of regularization? Can you please give us the page number?
Regularization order ta kothay? অর্ডারটা they have given me the temporary status with effect from 13th August 2007. Kindly comes to page 40. এখানে চ্যালেঞ্জটা কোন
Can you show us your regularization order?
এই অর্ডারটা কোথায় পার্মানেন্ট অর্ডারটা কোথায় may I just say this? Well, it kindly comes to page 34. Well, the tribunal had directed my status as a temporary to be taken from 87 onwards. 89, no, 87. They have taken this status from 2007. And that is why, my lord, if your lordship kindly see, my lord, the OA, page 13, second way, my prayer was that, my lord, that for an order directing the respondent to treat the continuity of service of the applicant from the date of initially joining with effect from 4th May 1987 be accepted in terms of the order of the CAT. Here, my lord, at page 34, they say, as per the Honorable CAT's order, the screening committee asked such and such, which was utilized as hot weather staff, to appear in the screening test. On the basis of recommendation, the authority dispose of the case by a speaking order. Further, Sri Sachansa submitted an appeal. After considering the appeal, the company authority revised the case and decided to consider his engagement as a substitute subject to medical fitness. Accordingly, observing all formalities towards engagement of substitute, whether by as a substitute order, he is with effect from 27 to 2007. So my continuity of service, my lord, had gone. And here, my lord, they themselves has shown that I originally, my lord, joined in 1987. And my lord, if your lordship kindly see, my lord, page 40. May I show 28th April 2009.
Where's your prayer in the OA?
Yes. My lord, in our page 13, the running page is, my lord, 33.
What is it that you want from the tribunal? Please read your prayer.
Yes.
A subsequent OA cannot be filed for implementation of an earlier order. That is one thing. If at all there is any infirmity, you are required to move contempt. So first prayer is hardly means anything. Prayer B.
My lord, kindly comes to prayer B.
Yes.
For an order directing the respondent to treat the continuity of service of the applicant herein from the date of his initial joining the railways with effect from 4th May 1987.
Continuity means what? It's very ambiguous.
Well, my joining originally from 4th May 1987, I
How
was
is that relevant? Now you have been regularized in
No.
2007 on 13/8/2007.
Well, my temporary status began from 2007. My temporary status was already there.
To page 37. Sir.
Yes, date of engagement as temporary status.
Forget about it. Just see the regularization. Now you are regular group D employee. Now that status, how it can relate back to 87 and
My
97?
lord, so far as that part is there, my lord, I lost, my lord, continuity of service. I lost all, my lord.
Continuity of service.
My lord, I lost all, my lord, monetary benefits, salary, unpaid salary.
There's no
all
question of salary to a substitute. You never came above a substitute.
Well,
This is the first time you have been regularized. Where's
well,
the question of any salary?
my lord, if your lordship, my lord, kindly comes to the order impugned, my lord, that even my lord, ignored the previous cat order. My lord, so far as
We are trying to understand what you actually want. Unfortunately, till now, I have not been able to understand. There is an order of the tribunal saying that your status as substitute cannot be discontinued, even though you are absent for 5 years. Substitute is only there in the roles when you give work, then only he will do it. If you have not given work, you have not looked for him for 5 years, why should we take it that he was absent? So you consider him for regularization. Now they have regularized you. What is it you want from retrospective? And what can you get retrospectively? If at all that break in service which they had said, according to you, for 5 years you were absent.
They have not shown me in service. They have.
That is history, sir. That is history. History laid to rest in the 2006 order when the tribunal said that you are nothing more than a substitute, just on the rolls. As and when work is given, you work, otherwise you don't work. So if you have not looked for him for 5 years, now you can't say he was absent. Had you placed anything on record to show that you wanted him to work on any day he was not there, then we could have taken it that he was absent. There is no such material. Tribunal has refused to say that you were absent and you are to be stripped of your temporary status. It says, no, your temporary status is continued. Therefore, you are entitled to be considered for regularization. Now you have been regularized. What is it that you want in retrospectivity?
They have considered me in service from March 2007 onwards.
So therefore, show us how you can be considered as a regular Group D employee before 2007. That's what we are asking you.
May I just check, my lord? May I just check?
What is there to check, sir? Everything is right here.
May I
Today is
just
the second day we are taking it up.
May I just, but at this point that your lordship will not have.
No, this point,
put
what
me
is
on-
your point? Let us see. What is your point? Tell us.
My lord, may I just see and come back, my lord, with this? May I just see and come back? I have followed your lordship, my lord. What your lordship are trying to, my lord.
You
put
have
me on
just read the order of 2006. 2006 order only rejects the railway stand that you were absent. Nothing more, nothing less. And that is on a very sound logic. It says that you are only a temporary status on the rolls waiting for work as and when required. During heat, summer heat, you are required to serve water in the train. That was the duty. As and when it was required, you were given that duty. 5 years, if they have not looked for you, they can't say that you were absent. So you cannot be deprived of your consideration for regularization. Now it has been granted. What retrospectivity is to be given? And how it can relate back?
My lord, I would definitely see and come back, my lord, and would give a positive and befitting answer. My lord, if for the time being, my lord, may I just take 30 seconds more? My lord, here, my lord, for the purpose of regularization, I need to have, my lord, complete, my lord, a 120 or periods of service. And that portion, my lord, I have already completed. That the original way cat order, my lord, has already reflected. Now here what they did, my lord, they have chosen, my lord, that period of completion from March 2007 and treated me as regularized in June 2007. Maybe, my lord, that my lord, I would again, my lord, consider this aspect.
No, what consider? Come to page 37. How many times you will consider? The following substitutes are absorbed against Group D category, and their particulars are mentioned against it. You have been absorbed.
No, because but they have shown me on duty from 33 2007 and gave me my status on 10th July 2007. So this 120 days,
Instead of this, what it should be? Tell us. And what difference it will make to you?
well, may I just see and come back? May I just see and come back? I would not, I may see and come back.
Come tomorrow, not today. Hold matters unnecessarily pending for nothing.
Well,
Well,
there are 2 more days. Well,
no, sir. Tomorrow.
wait.
Item number 19.
Mr. A.K. Gain, learned advocate appearing in this matter. Also, Mr. A.K. Gain, learned advocate appearing in this matter for the petitioner. Due to sudden medical emergency, he couldn't come to the court today. Lordship, kindly fix this matter day after tomorrow. Grateful, Your Lordship. Lordship, kindly fix this matter day after tomorrow. Okay, grateful.
My lord, Ms. Sushmita Shah is appearing for the petitioner, my lord. There was a direction to submit a report regarding the matter filed before the Telangana High Court, my lord, but no instruction we have received. My lord.
There is an order.
Yes, my lord.
You also don't know what happened. You are the Union of India. So why you are supposed to know?
My lord, we have asked for the report to the department, my lord, but my lord, they are not able to.
You are the advocate on record.
No, my lord, Ms. Sushmita Shah is up.
Go and call the advocate on record.
In that case, my lord, kindly fixed at 2 p.m., my lord.
Yes, ask her to be here.
I should very kindly
Item number
before your lordship,
21.
there is a very little scope. 7 except the last line, paragraph of the order under challenge. But if you kindly, I should not trouble your lordship. It starts from page. My lord, the last page. Impugned order, my lord. My lord, we lost there. There is no. My lord, it says, if, however, the respondent number 1, namely the Steel Authority of India Limited, decides to introduce GPA cum pension scheme for its employee at any point of time, the competent authority in respondent number 1 shall consider the claim of the applicant in this way in the light of the scheme for enabling them to switch over from to the GPA cum pension scheme. The fact that the applicants have separated from respondent number 1 should not come in the way for consideration their claim on which the applicants have been agitating since 2011 if they are otherwise eligible in terms of the scheme. Well, this order, my lord,
Separated means?
means probably, my lord, they all are retired, superannuated. Admittedly, all are retired, some has been expired. My lord, with this, my lord, rider, my lord, we came before your lordship. My lord, praying, my lord, let it be considered by the Steel Authority, either way. This is my only submission.
Milord, you are the applicant.
Milord,
This futuristic direction is in itself a unique kind of a direction. What more is to be done?
Milord, before that, Milord, I like to point out one. Milord, before that, I like to point out one anomaly. Milord, earlier.
So you want that instead of they should consider it right now?
Well, within, my lord, if your lordship so directs within a time, my lord, because
How can they, when there is no scheme, how it can be considered?
I do not know whether there is at all any scheme or not.
No, you can't say that. You are the applicant and you have got an order which says as and when the scheme comes.
Yes.
So where have you said that there is a scheme? Let us see.
স্কিমটা হয়েছে, স্টিল অথরিটি স্কিম করেছে, জজ সাহেব সেটাই বক্তব্য। কোনো স্কিম হয়েছে কি?
না,
তাহলে সেটা বলে দিন, তাহলে ছেড়ে দিন।
No, there is no scheme.
লাভ
No scheme. They are all that they are following CPF scheme.
We have understood. See, they have probably, I don't know, we have not gone through the order. Probably they were saying that many organizations are having pensionable service, give us also pension. Probably that is what they have come to the tribunal for. Tribunal, after seeing thing, has said that if a GPF pension scheme comes, you will be considered. How it can be improved? That is what we are asking.
But that I also not help your lordship. But this rider, my lord, has give some light in our favor that if the scheme is introduced, then our case. If the scheme is not introduced,
Actually, you just see your prayer. Can a tribunal direct a policy matter?
Absolutely.
You see the prayer at the first page of the impugned order. Revoke the impugned system of paying CPF and in lieu to introduce the GPF system of pension which is fully how the tribunal can pass such an order?
That I cannot, my lord, say anything further because I was
Fortunately,
not
fortunately, they have not challenged the order.
Yes.
yes, they have not challenged. Only this have given
Item number 22.
My petitioner. Lord, I appear in this matter for the Lord, Petitioners Union of India. Lord, I would only draw your Lordship's kind attention to Lord, the impugned order, paragraph 11. Kindly see, Lord.
Hmm. Hmm. 11/4/19. What is the date of the order?
Lord, 11/4/19.
Yes.
Kindly see paragraph 11, where the crux of the matter has been reflected. Now, the thing is this, the claim of the railway authorities has been thrown away by the learned tribunal, and the original application was allowed in favor of the applicant. Thing is this, the inquiry, formal inquiry was not necessitated.
Where is JPO 99? Where is it?
That is quoted at page 8 in the impute. It is quoted.
Page?
Page 8.
Please read the quotation.
Page 8, paragraph 9. However, subsequently in their clarification reply submitted on so and so, paragraph, they have specifically.
You are quoting this, quoting of your reply, not JPO 99. Whatever it is, that means the catering manager, if you say tomorrow 1.5 crore he has to pay. That is the sum and substance of your submission.
In terms of the earlier order by coordinate bench, that we were asked to file.
No, we are not interested. What is the infirmity in the order? Why should we look into it?
No, but we have filed the supplementary affidavit.
We are not required. We will confine to this order. What is wrong in this order? You say that 55 lakh rupees we have to recover from him. These are catering credit.
That was required to be
paid by him, which he has not paid. The tribunal says, from where you are getting this figure? You don't show anything. You say we are not required to go into this. What we have said he has to pay. How you can justify this? Tell us.
Table reconciliation was done.
Don't say that. Your stand is that reconciliation is not required.
Formal inquiry was not required. That was
reconciliation is not required. Show us where the reconciliation was done. Where you have said in your reply before the tribunal that reconciliation was done.
But in the affidavit filed by the respondents.
Please read where you have said that a reconciliation was done, where the authority and the petitioner has signed. From there we get an amount of 54 lakhs, whatever odd amount you say, it is nearly 55 lakh rupees. And therefore he is liable to pay this amount. Where is your reply filed before the tribunal? Which page?
Page 56. 56.
Yes, where have you said reconciled? Where is this JPO 99?
But that is possibly annexed. Now let me see, my lord.
Para 3 of JPO 99.
Page number 78.
78, right.
This is a JPO, Joint Procedure Order.
Kindly see, my lord, the last but one paragraph. That is possibly relied upon by the railway authorities.
So your answer is there. No. You see what it says, amount of debit thus completed as part 1.
Right. Should be remitted on the spot. That
Please,
was exactly
please read, please read.
remitted on the spot by the catering manager. The full particulars of the remittance are to be furnished on the face of the report. Any incidents of non-remittance will be reported to the
CCM, Chief Commercial Manager, perhaps, we don't know.
Yes, an official through AOCD. In absence of specific remarks of the catering manager for non-remittance of the part 1 amount on the spot, he will have to be taken up.
Discipline and appeal rules. So if you have to give him, he has to give a remittance. If there is a shortfall in the accounts or some cash is short, at the spot he has to hand over. If he does not hand over, you have the option of reporting it to the CCM, and CCM will proceed under the discipline and appeal rules.
That is the course of action which is to have been followed.
That is why the court is asking you how to. Only if you give him this charge memo, then he can respond whether. And we don't know whether the report was sent to the CCM in time or not. All those things are not here.
But since the claim is very heavy for an employee, it is definitely heavy amount.
No, but if he has misappropriated, he will have to either suffer the consequences, or if
subject to your lordship's kind consideration, Lord, can I seek for modification of the tribunal's order to the extent that in view of JPO, the course of action be taken, Lord?
Who is stopping you? That is, we will clarify.
No recovery can be made. Tribunal has clearly directed.
Correct. No recovery can be made. To that extent, we are in.
Unless the JPO is followed strictly.
Yes.
That part I will object, my lord. I tell your lordship, all these incidents were, my lord, back last of 1998. I retired, my lord, in 2007 from the railway. This office order was issued in 2013. And my lord, I tell your lordship, my lord, this part that they are, my lord, contradictory stand. On one hand, they are saying that no inquiry is required. On the other hand, they are saying, or my lord, no inquiry and table reconciliation is required. And on the other hand, my lord, they are saying that table reconciliation is being done. So, my lord, this was also taken care of by this honorable court on the my lord, earlier orders, where my lord, this
We have seen the earlier orders. Actually,
Yes.
we should not be entering into this.
Yes.
Whether they have reconciled, reconciliation is sustainable, not sustainable, signed by you. Not, how can the writ court enter into this arena? And if we find that yes, it is reconciled, then should you be directed to be paid, to be paying them?
Follow your lordship. Follow mine.
Therefore, that exercise at the moment, they say that 54 and odd lakh rupees are to be recovered from you. Tribunal says why. They are unable to clarify why.
Yes.
They say as per GPO, he was required to pay there only JPO.
Yes.
The moment the train stops, it appears that they come to you, they say what has been the sale, what has been the consumption. If there is a discrepancy, then there is an amount which they raise and you are supposed to pay then and there. If you don't pay, then they have to report to the CCM.
Yes.
And once the CCM compiles everything, he will decide whether there is enough of a shortage to proceed against you or he will not do so. That exercise, obviously, they have missed after decades. In some audit, it must have emerged. So they have issued the requisition to you. Now, that is not sustainable. Why should we go into whether the amount, how much it is, 54 lakhs, 55 lakhs, 70 lakhs, maybe 20 lakhs, we don't know, even if it is 5 lakhs.
Follow you.
This writ code cannot direct you to pay the amount. It has to be established in a proceeding. Now, JPO, we cannot interfere with. He is saying I should be granted liberty. Obviously, it will be in accordance with law.
In accordance with the law, because my lord, railway service
Has to be.
pension rules, my lord, rule 9, my lord, specifies how, my lord, this has to be done in case of the retired employees. They will have to do that thing.
Correct. So it has to be in accordance with law.
I only seek for the
because that
modification of the order.
because that subject to correction of my lord senior as well as your lordship, my lord, that is not permissible as per rule 9.
So then they will
Yes,
not be able
yes.
to.
So lordship will not kindly grant them liberty.
No, we are
Yes.
not going to
Liberty
grant them
according to
any
the law.
liberty. We are going to
Yes.
say
Great.
that we'll, yes, take up.
Great.
The
23.
I am for the petition number 23, 24, 25, same matter, my lord. See. A petitioner seeking
23.
employment for land loser, my lord. Tarkeswar Bishnupur Railway Project.
My lord, we are permitted to submit our affidavit in opposition.
Have you got the SLP numbers now?
Lordship,
Have you got the SLP numbers now?
my lord,
I have got verbal instructions that certain files have been sent to Supreme Court for filing a statement.
You have been giving us this instruction for more than a month
my lord,
now.
my instruction is a little bit developed. That SLP has been drawn. It is in the process to file. Perhaps by this week it will be filed.
So the same order will pass in this. Which matters? How many?
3 matters, my lord. 23, 24, 25.
Yes.
I'm 20.
We are, my lord, I have got 23.
24, my lord, we have filed the affidavit in opposition.
Today.
24.
So in all three it is being filed.
23 right now I have filed.
And 24 you are filing. And 25?
My lord, credibility in the 24 matter. My lord, they have not challenged the order of the tribunal.
Oh, my lord, now I will satisfy.
Let us see, we are not going to, unless.
A format has been given, my lord, all in such cases.
Yes, are you filing in 25?
But my lord, only one copy were there. That is the problem.
Can you file it during the course of the day?
Yes, we can.
So in all three matters you record. He is in his presence. If it was not filed, he would be objecting. After holiday. Give a date. Why not? Give a date.
Development কি হচ্ছে?
ডেট দিলে কিছু ডেট দিলে কিছু
29th October.
29.
29.
Item number 26.
Mr. Rai, you please ensure that it is filed in 25. Yes.
26, I appear for the petitioner.
I am
Government of
appearing-
India is before your lordship against the order of the learned tribunal. My lord, this is in connection with granting of the benefit of modified assured career progression scheme framed by the Union of India.
Third.
Third benefit.
MSCP is third benefit.
It is the specific case of the postal.
After how many years? 25?
No, 10th, 20th and 30th. First is after 10th year of service, the next is after 20th year of service, and the third is after completion of 30 years service.
So 30 years, total 30 years.
Total 30. it is the specific case of the Union of India that before completion of 30th
You are for the Union of India.
Union of
Hello,
India.
there is a Section 5 application, substitution application.
But after filing, we had informed that some of the
Delay is 165 days.
made an application for substitution. No record was there. That is why there is a delay.
Anyway, so it happens. Many cases there is a condonation and substitution. That is not, we are not trying to say anything that it goes against you in any way. But then what is the issue? The tribunal has directed to grant the benefit.
Grant the benefit, but it is the specific case of the Union of India.
Why they should not get? Just tell us.
That after completion of 20th year and before completion of 30th
They got a
year,
promotion.
there was some advancement in the pay scale. That is why it was initially not granted.
Why? The post was upgraded.
Post upgraded and
So let us see under the MSCP what it says about upgradation. That is the only issue.
Go by the department that on the self-same issue, one special leave petition 11997 of 2019 is pending before the Honorable Supreme Court of India. One special leave petition on the self-same issue is pending before the Supreme Court of India. The number I have got from the department, my lord, 11997 of 2019.
No, the point is, see, you say that between 20 and 30 years, they have got an enhancement by way of upgradation of the post. Therefore, they are not entitled to, there is no stagnation. Third MSCP cannot be granted. This is your stand. So what is the provision in the MSCP? Let us see. Upgradation is to be treated as a promotion, then they have no case.
Kindly come to page 19, annexure P3 of our application here. 19. Lord, at page 20, two tables are there, my lord. Kindly come to the second table. Rate pay is 1800 to 1900 and 1900 to 2000. It is treated as the first regular promotion. And if it goes to 2400, it is treated as the second regular promotion. And at page 21, second table, my lord, table 2, from the postman to TBOP and thereafter postal assistant, there is an advancement of the scale. From 3200 to 4900, when he becomes the postal assistant, it is 4000 to 6000, it is a regular promotion. Pay fixation under financial rules. The clarification is there.
Service, what is his service career? He joined as MTS.
4A to 4D, I am explaining. Kindly come to page 7 of my application, my lord. Paragraph 4, clause D. The present case, all the applicants except applicant number 1, that is Sheikh Moinuddin, and applicant number 9, are found to have already earned one promotion to PA cadre through the departmental examination and awarded date pay of ₹2,400 and one financial upgradation under time bound one promotion scheme for which they have been awarded rate pay of rupees 2,800. And so far as the two other are concerned, my lord, in clause E and clause F, I have given how they are, except 1 and 9, the others
They have been granted.
granted. And
So 1 and 9 have not been granted.
yes.
Why? Where have
Kindly come to clause E, page 8.
E?
Yes, page 8, clause E. The applicant number 1, Sheikh Mohinuddin, who earned the postman cadre on such and such date and promoted to postal assistant cadre on such date through departmental examination with rate pay of 2,400, which was treated as first MSCP under the existing scheme, and awarded the second MSCP with rate pay of 2,800 with effect from such and such date, and do not fall under the TPOP scheme. He was granted regular promotion to LSG cadre. Form of LSG. By order number such and such with effect from 30th to 23rd July 2019, which he declined by his application number dated such and such. He was offered the promotion, he did not accept.
So that is for your stand regarding 1. And what is your stand regarding 9?
And regarding 9, the applicant number 9, that is Nomita Boitto, who earned the postman, entered the postman cadre on such and such and promoted to postal assistant with rate pay which is treated as first MSCP, awarded the benefit of TPOP time bound with rate pay of rupees 2,800. The official retired on such and such date and would have completed 30 years on 2016 from entry date. In 2014, he retired.
So regarding 1, you say he has foregone 1 promotion, he is not entitled. Regarding 2, you say if she never completed 30 years, therefore there is no.
Completed 30 years. And so far as the others are concerned, all have the same case dealt with.
But others you say you have already granted.
Yes.
So regarding others, there is no dispute.
No. From our side, there is no dispute. They are claiming that they would get further.
No, but you have filed the writ petition. They have not filed the writ.
They were granted third MSCP with debt pay. So far the others are there. It is our case that they have already been granted.
Tribunal has got directed to give everyone the.
Everyone. One contempt application is pending, my lord. What's it? It is there on day after tomorrow.
Where is the order promoting them as postal assistant?
Orders are not annexed here, my lord.
No, that is where the dispute lies, whether it is a promotion or not. So where is that order? Let us see. That will clarify everything.
Actually,
they entered as postman.
Postman.
Then they became postal assistant. You say it is a promotion. They say it is not a promotion.
When we come to the clarification at 20 and 21, which I have placed earlier, they are.
No, that clarification does not make any difference. Where is the order?
Postal order of the concerned persons.
Yes, because that is the only dispute, whether it is a promotion or not. The tribunal says probably that it is a fresh, because their cadre or something has changed. What is the finding? What is your case? It is not a fresh. It is not.
They are not given the that benefit.
Postal assistant cadre on when you have come in the postal assistant cadre, it was not a promotion.
No.
Why?
So, Lordship, kindly grant us some time we are obtain the
Time, sir.
For your Lordship. The orders are not. Submit all.
Where is your reply filed before the tribunal?
একটা ম্যানেজার মানে no way application is annexed, no reply.
Now it is not surprising. Earlier I used to feel surprised. Now it is
That's why মানে Justice
a
Chakraborty,
routine, especially when the union files, it is a routine.
that's why Justice Chakraborty adjourned. You'll also kindly see the earlier order.
And you have taken no steps from September 24. Have you filed the 2 CAN applications?
Two CAN application was filed. One is substitution application and another is condonation of delay application.
So they have taken steps.
Delay is 165 days.
Where is the CAN? Substitution?
Because we
No, because all have not made. Which application?
CAN 1
And one is for application for substitution.
two
And two is for
condonation of delay.
165 days.
And 3 1, 2 and 3.
No, CAN 1 is not for substitution. CAN 1 is for delay. CAN there is no CAN. There is no application for substitution in our records. When have you filed it?
CAN 3 is substitution.
We haven't got it in the file.
All are substitution. 2 also substitution.
When have you filed, sir?
Recorded file, sir, it is filed in June 2025.
There must be a filing number.
My copies, no number is there. Can gap.
5 respondents.
5 respondents have died, my lord. Respondent numbers 2, 3, 5, 9 and 12.
And where is the detail of their legal errors?
Whether service has been complete or not.
Hmm?
Whether service has been complete or not.
You are representing all the
Yes,
respondents.
he is
Only one.
okay.
9. 1 and 9.
1 and 9. That case, my lord, so what as the others are concerned, we will have to serve directly upon the parties.
Serve the copies.
Yes, yes, we will start.
Let notice of application.
কবে হলো? Day after tomorrow is the date for contempt application in the learned tribunal. May there be a limited day.
That I do not know. I have.
He is saying day after
Lord,
tomorrow.
application for contempt is there. It is
No, application. What is happening? There is a direction for personal appearance or anything of the kind.
Personal appearance is not directed.
Then we'll see. Let it come after 2 weeks. If there is something happening, you can mention. WPST. Oh, list of dates. Yes. What is CR within bracket W?
That's the contempt root, contempt.
W or WPRCRC will contact group issue connection with that.
Item number 6.
We were on way that there is some resolution.
This is a judgment, my lord.
Huh?
The judgment has or possibly already been passed.
Yes.
As your lordship wish.
Because it's fixed at 2 p.m. therefore we are saying. If there was no time indicated, we would have done it. We were just wondering on the way that if both sides are not,
There is a resolution.
then we'll deliver it tomorrow. Not. Are you aware of the benefits regarding his, special leave and double TA?
Double TA has been refused, my lord, possibly.
Rejected already.
Yes, yes.
That is not subject of the OA. In the OA, the tribunal has directed that since it is dependent upon examination by an orthopedic, therefore he should go and get himself examined by the orthopedic.
Yes,
so what we just wanted to know whether after that he has been examined, it has been granted or not granted.
No, my lord, possibly after the matter was.
Nothing has done. So just get the current status about this.
Well,
So if there is a change, then in the order we may be required to slightly modify. Send it to.
Item number 7.
I beg to appear for the Union of India in this matter.
Your Lordship, I am representing the petitioners.
It was heard on the last occasion by your Lordship at length.
Heard.
It was fixed for orders.
তোমার ব্রিফটা থেকে আমি একটু করছি এখন আমার কি পাকানিটা থেকে কে বলেছে পাকানি মেরে রেখে চলে এসছে Thank you.
Can you please refresh?
Lordship, this is regarding the selection process which was vitiated. The petitioners were selected and appointment letter was awaited. Now, Your Lordship, the entire selection process was kept in abeyance for more than 2 years. He filed RTI applications and the respondent replied that due to some unfair practices, it has been kept in abeyance. Later on, Your Lordship, another recruitment process of similar identical posts were published in 2011, 2012, Your Lordship. He had applied, but he was not given the admit card. He could not participate. Your Lordship, he came before the Honorable Tribunal in 2013 June when his repeated appeals were not considered for issuing the appointment letter. Previously also he was selected in the same post in another ordnance factory which was in Nagpur, Your Lordship. So after interim protection was granted to him in July 2013, Your Lordship, by the Honorable CAT, the respondents did not reply for a long time, and later on in September 2013, they informed the Honorable Court that the entire process has been vitiated. Now fresh retest will be conducted for all those applicants who had participated in the earlier examination, even if they had become overaged.
You had already been required to go for training.
No, Your Lordship, all practical and written tests were conducted, and
The result was declared.
I was
Declaring you
selected.
as selected.
Yes, Your Lordship, and in my merit list, my position was second, Your Lordship. Now, after 2014, Your Lordship, this petitioner had filed one miscellaneous application before the Honorable Tribunal so that the retest can be stayed till the result of till the order is passed in the Honorable Tribunal. But the Honorable Tribunal directed him to participate in the retest
Subject to result.
Subject to and his contentions will not be prejudiced. He moved an application before the Honorable High Court. Honorable High Court had the similar observations that you participate. He participated, Your Lordship. Later on, this final order was given by the Honorable CAT in 2018, Your Lordship. But the result of retest was never declared for 4 years, Your Lordship. And on the submission of the response.
What happened in
2018, the order of Honorable Tribunal was passed.
Final order.
Final order was passed on the ground that he had participated in the retest.
What did the tribunal direct?
Tribunal, the interim protection which was granted for both the petitions in 2 posts, the interim order was vacated and it was dismissed, Your Lordship, on the contention that he appeared in the retest and the result is not yet declared, yet it is up to the wishes of the respondent. Now, Your Lordship, I had moved this WCT before the
that order is challenged here.
Yes, challenged here. Then this WPCT was also, this application was also dismissed on 2 grounds, that he could not qualify in the retest, and secondly, he did not submitted any application for the second set of recruitment process of 145 vacancies, Your Lordship, which was published.
Did not submit an application. What does that
Did
mean?
not submit any application form for participating in the subsequent recruitment
In spite of
process.
liberty granted by the tribunal.
No, liberty was granted for retest of 27 vacancies, which was vitiated, Your Lordship. And the subsequent recruitment process drive was of 145.
Oh, so that was a fresh process.
Fresh process, but
For that you did not take any
I took, Your
liberty from the tribunal. You had.
I took and I had submitted the application at that time only.
And
Your
what
Lordship.
happened in the subsequent process?
Subsequent process was carried forward. I was not issued the admit card for which I could not participate. But on this.
So the first was cancelled, second process was frustrated because you were not issued the admit card.
Yes, Your Lordship. And on their submission that he had not submitted any application for the subsequent, this writ was dismissed, Your Lordship. On these 2 grounds, I had moved a review application and the review application was admitted. And the order of dismissal was set aside. Now, Your Lordship, this original writ application is before Your Lordship.
Oh.
And the retest results were also not declared. That too has been cancelled.
Which was not declared?
Retest of 27. It was dismissed.
The retest was obviously it was aborted. Therefore, a fresh recruitment process must have.
No, Your Lordship. This was simultaneously, almost simultaneously, these 2 recruitment.
So these 27 vacancies were not part of the subsequent recruitment process.
No. Few
No,
13 vacancies of fitter mechanic was there, Your Lordship. Although
no, the retest was for 27 vacancies.
First was 27 vacancies.
And the fresh process was for 145. 45. So that 145 did not include this 27.
As per their.
No, what is your case? You must have said.
My case is that these vacancies are also reflected in the subsequent vacancies. But I was granted.
If that is your case, then how can you claim the result of the earlier process when you know that all that has merged in the subsequent process?
No, I cannot confidently say, Your Lordship, that because 27 seats
we are asking is what is your case? What do you say?
Your Lordship, 27 reserved vacancies were there in which I had participated.
You were a reserve category.
Yes, Your Lordship. So subsequently, 145 seats were declared, in which I was given protection in 2 seats, Your Lordship, in subsequent recruitment process of 145 candidates. This this interim protection was cancelled, Your Lordship, during the passing of the final order by the Honorable CAT, just because I had participated in the retest.
So now we have to see which order.
The order passed by the Honorable Tribunal, Your Lordship, which is at the end of the application.
আস্তে আস্তে ঠিক আছে না এই তো এখানে আছে তোমার
43 to 50.
So now we are to examine the tribunal's order.
Yes, Your Lordship.
Which order of the tribunal? 11/7/13.
2018 order, Your Lordship.
18.
2018 August. Last 130 is in page number 124, Your Lordship. 124 of WPCT 2, Your Lordship. 27th March 2018. May I read out, Your Lordship? (125)
636 of
Yes, Your Lordship.
2013.
Yes, Your Lordship. Para 3, Your Lordship. Roman 3, page 125.
So what was the result of the retest for 27 posts?
The result was not declared, Your Lordship.
Till
It was
date.
conducted in 2014 November, while the order was passed by the Honorable CAT in 2018. The result was not passed. 137, Your Lordship, in the last
No,
paragraph.
but the tribunal has given liberty to
Yes.
declare the result.
Yes.
After that also not done.
During the review hearing, they came with the documents that the entire retest has also been cancelled.
Oh, that has also been cancelled.
Cancelled, and no
Vitiated.
intimation was sent to us, Your Lordship, to any of the petitioners. And this petitioner was disappointed and he was frustrated thrice by the respondents. Once, first by the cancellation of the entire recruitment process after he filed the application before the CAT. Second time, when he was not given the opportunity to appear in the vacancy of 145 candidates, Your Lordship. And on the third, when results were not declared after 4 years, Your Lordship.
জমা দিয়েছি তো এটা জমা দেওয়া আছে
Lordship, in page 31, another appointment letter has been enclosed, which was given to him by the Ordnance Factory Board for the same post for the Ordnance Factory at Pune, Your Lordship. His eligibility has been tested time and
So
again.
this has been disposed of in terms of an order passed in another writ petition. This case was listed with another writ petition.
Yes, Your Lordship. Two petitioners are there.
So the order on merits has been passed in WPST 1 and this case has been held to be covered by that order.
Yes, Your Lordship. Yes.
So, where is that order passed in WPCT 1?
WPCT 1 is page 125, Your Lordship.
Reviewer
124 onwards.
no WPCP 1
WPCT 1.
and my lord it's annexed with the review application my lord it's at page 18 of the application for appropriate order in connection with the review. Is it
WPCT 1.
WPCT তে পাবে কি করে
So, all right, then what is wrong with the tribunal's order? Let us see.
Your Lordship,
What is your contention? They
Yes,
could
my
not have cancelled the process.
yes. First, that I was not given opportunity to appear in the subsequent process, Your Lordship, which has been mentioned that I had not participated in the subsequent recruitment process of 145. That is in page 130, Your Lordship. It is mentioned there in the order. And secondly, Your Lordship, the entire selection process of this reserved candidates were
No, even if you have applied or you have not applied. The point is whether that selection process, having regard to the reasons which they have brought before the tribunal for cancelling, whether that will sustain the cancellation or not. Whether you have applied or not, how that is relevant for the cancellation.
no, that is not relevant, but I was deprived of getting a fair opportunity, Your Lordship.
That is your contention, that we understand. But then the two issues, where do they meet? We don't see the two issues meeting.
Because, Your Lordship, in this 145 posts, I was given interim protection in two. Two petitioners were given protection in one post of fitter mechanic and one post of.
In the subsequent advertisement.
Yes, Your Lordship. Just because I was deprived of this opportunity, as well as because my previous selection process was cancelled without informing me or without any fault.
Where is
on
that
my part.
order giving you the interim protection?
Yes, Your Lordship. It is page 43.
Page?
Page 40. Yes, 43, Your Lordship. First order, the factory was directed to come before the Honorable Tribunal. Then in page 45, Your Lordship, paragraph 2, with regard to grant of interim protection, WPCT 2, Your Lordship, page 45.
Why don't you file a paper book? Is it possible to go through this way? You are referring to page 45 of what?
WPCT 2. I will refer WPCT 2, Your Lordship, because WPCT 1 is based on the order of WPCT 2. Page 45.
45?
Yes, Your Lordship. Paragraph 2. With regard to grant of interim protection, আমি বার করে দেবো একটু দিন আমাকে বার করে দিন।
File is not organized. How anyone can find anything in this? I don't know, just organize this. It's possible to locate anything. Everything is just lying there.
WPCT 2টা দেখুন।
Find anything. You are referring to WPCT 1 or 2?
2, Your Lordship. 2.
WPCT कहाँ है? Where is the red petition?
May I read out, Your Lordship? On 11/7/2013, we indicated that respondents shall file reply, and upon filing reply, the prayer seeking interim protection of stay of the said notification of November 2012 can be considered. The learned counsel for the applicant submits that if the posts are filled up, he would not be considered despite being declared successful in the earlier examination. No reply has been filed till date. We direct the authorities to file reply within 4 weeks. With regard to grant of interim protection, we direct the appointment to one post in subsequent notification of November 2012. In future, general mechanic shall abide by the result of this application.
There were two writ petitioners.
Yes, Your Lordship.
Then why only one post?
Your Lordship, 1 and 2 are identical, only the
So in
post.
both cases, the same order was passed.
Yes, yes, yes. Only the posts are different. One is mechanic.
So from this, we cannot say whether you applied or not applied. And still we are trying to understand how does it make a difference whether you applied or not applied.
Your Lordship,
The cancellation of the recruitment process is supported by assigning certain reasons. Whether in view of such reasons they should have cancelled or they should have proceeded to make selection on the basis of such an examination.
they proceeded, Your Lordship. They conducted retest. They made submission before the Honorable CAT and they conducted the retest in 2014, Your Lordship. They tried to.
So they made all efforts, still they could not.
They made, but they did not declare the result, nor they took any effort to consider them for the second time in any retest. For
How can they, unless you apply for the second time, how can they consider? And that is not the issue before the tribunal.
No, Your Lordship. Retest in 2014, retest was conducted. Till 2018, they did not declare the result. But on that ground, Your Lordship, this writ petition was dismissed. That since I have appeared in the retest result.
That is not a ground.
No, retest result is yet to be declared. This has been observed.
Where is that? Let us see.
In page 137, Your Lordship. The Honorable 130, Your Lordship. First paragraph.
Yes. 130.
130, Your Lordship. That there were 130 WPCT 2. No?
What is the date of the order?
Date of the order is 27th March 2018. The final order of the Honorable CAT, Your Lordship.
CAT?
There it has been observed by the Honorable Tribunal.
My lord, internal page 7, my lord, of that order, include order.
Yes. Page 7, top, Your Lordship. That there were two distinct recruitment processes. The first against 27 vacancies as advertised between 4th and 10th September 2010, and the second for 145 vacancies as advertised between 20th and 26th October 2012, and that the applicant had applied against the recruitment process advertised in 2010 against 27 vacancies and not against the subsequent recruitment process of 145 vacancies, Your Lordship. This contention is wrong.
You said because of that it has been dismissed.
No,
there it is just recording the submission of the party.
Recording, Your Lordship, but subsequently.
That is not the reason for dismissing. We are saying where is this finding that because she has participated or he has participated, therefore this nothing is to be done in this proceeding.
The first dismissal order by the by this honorable court, there it has been mentioned.
There also we have not been able to find. Let us see what you are saying.
In the review application, Your Lordship, the order of this honorable court has been enclosed.
Yes.
There it has been mentioned.
There the court says there is confusion whether you have participated or not participated. There is no finding that you have participated.
But on that basis also.
Let us see where is it. Let us see where does it say.
Yes. The order is at page 13 of the CAN. Review application CAN.
না না 13 না 18 দেখো ভালো
এই-
18 থেকে স্টার্ট হয়েছে 18.
Review application can 1554. Review application page can page 19, your lordship. From 18 the order starts, dated 9 August 2019. May I read out, your lordship? Actually, your lordship, there are two sets of records, one of review and one of the WPCT, your lordship. And so many pleadings are there. Your lordship may kindly.
My lord, may I assist your lordships, my lord? My lord, the only in respect of WPCT 1, my lord, review was filed, my lord. So my lord, my learned senior and my learned friend is probably referring to that, my lord. I believe that on the CAN application from page 18, application for appropriate order in connection with the review, my lord, it starts from page 18. What I humbly beg to submit before your lordship, with regard to WPCT. With regard to WPCT 2, my lord, with regard to WPCT 2, review was filed only with regard to WPCT 2. Apologize, my lord. And this order of this honorable revision bench of this honorable court, that starts from page 18 of that application CAN in connection with the review. CAN number, my lord, it's 1554 of 2020. রিভিউয়ের ফাইলটা দেখুন, রিভিউয়ের ফাইলটা এখানে আছে, my lord.
Page 19, your lordship.
Participated, therefore nothing is to be done.
Yes,
Please
your
read.
lordship. The petitioner was granted liberty by the tribunal to appear in the retest without prejudice to his rights and contentions. It is not in dispute that the petitioner did not succeed in the retest. There is also some confusion as to whether the petitioner had in fact offered his candidature for the 145 vacancies. Recruitment process in respect whereof was initiated by the notice issued in November 2012. The respondents had contended that the petitioner did not apply, whereas the petitioner's response was to the contrary.
The court affirmed the tribunal's finding that you did not apply. Read the next paragraph, madam.
However, the tribunal was satisfied that the petitioner had failed to produce any credible material based whereon it could be contended that with any degree of conviction that he did not offer his candidature.
That he did offer it. That he did offer.
He did offer his candidature
Yes.
for the appointment in any of the 145
So
vacancies.
the court has not considered this relevant at all. It says you are saying one thing, they are saying one thing, and the tribunal has found that you did not participate. So this is only irrelevant. And then the court has proceeded.
No, your lordship, this is not based on the material documents which was produced before the review court. I had filed the what is bank acknowledgement of receiving my application fee.
So again, we are asking you whether you applied or not. How is that relevant to cancellation of the earlier recruitment process?
It is not connected with the recruitment process of
Then-
the earlier selection
then-
process, Your Lordship. Since I was not given opportunity in the subsequent recruitment process, I moved before the Honorable Tribunal, Your Lordship. That the subsequent process may be conducted after considering our vacancies.
We don't know whether you have sought an interim order from the tribunal saying that keep a post vacant. If you had applied, you would not have approached the tribunal for such a
I had applied, Your Lordship.
in the 145 vacancy.
Yes, Your Lordship. In the review,
Anyway, even if you have, so what happened in that process?
they have selected 138 out of 145 candidates.
And what
Your
happened to you?
I was not considered, Your Lordship.
What do you mean not considered? You emerged unsuccessful.
No.
He did not participate, my lord, and before the honorable tribunal, it was not a prayer also, my lord.
Yes.
I was told that I had not submitted application, but later on it is found that I had submitted.
How the tribunal can go into the subsequent recruitment process?
Your Lordship, one recruitment process was cancelled without any information, and
You have said that sufficient number of times.
Yes,
We are now having a clear view of what happened. You applied, 27 vacancies were there. For some reason, they did not proceed to process the recruitment. You approached the tribunal. In the tribunal, finally, it emerged that they are giving you a retest for the same recruitment process. You say you participated in the retest also. No result declared. You came to know that a fresh recruitment process has been advertised for 145 vacancies. Now, how does that have any bearing on the earlier?
Your Lordship, the 145 vacancy were published in 2012, Your Lordship, and retest was conducted in 2014.
All right. But nonetheless, it remains a subsequent recruitment process.
Yes.
Whether 12 or 18, that is immaterial. Now, how that has any bearing on the cancellation of the earlier recruitment process?
Your Lordship, as per the government rules, reserved posts, if any recruitment process is initiated only for the reserved category, it has to be accommodated sooner or later, Your Lordship. It cannot be left in vain, which they have done, Your Lordship. I, being a candidate from the...
That is not the issue before the tribunal. It is not that you file an OA and you keep on enlarging the OA for all recruitment process that take place
No, Your
thereafter.
Lordship, it could not have been enlarged had they not submitted for retest, or had they
That
declared
retest is
reserved.
immaterial. That was in the same recruitment process. So that is not the issue. The issue is whether the subsequent notification of 145 vacancies, that would have any bearing on the OA. How that will have any bearing on the OA? That cannot.
I was not given the
don't
admit
know.
card, Your Lordship.
We don't know whether you challenge that or you did not challenge that 145 vacancy advertisement that I have not been allowed to
Your
participate.
Lordship, in
Where
the
is the challenge? Show us.
OA was...
Show us show us in the OA where you have
Yes, Your
challenged.
Lordship. Your Lordship, in page 57, the order of the Honorable Tribunal is there, Your Lordship.
Petition.
Copy of the OA is with me, Your Lordship, but it is... The prayers are mentioned in the order passed by the Honorable Tribunal. The prayers which are at page 124 onwards, Your Lordship. By what I had prayed for, Your Lordship. (125), Your Lordship. My internal page 2. aggrieved by the non-receipt of appointment letter to the post of fitter mechanic, semi-skilled, OBC category. An application has been filed under Section 19 of the Administrative Tribunals Act seeking the following relief. Immediate issuance of appointment letter to the petitioners without any further delay. The urgent order of status quo may be issued on the new recruitment process initiated by OF Damdam with online registration application. The respondents be directed to suitably compensate the petitioner for harassing and causing irreparable loss to his career progression. The respondents be directed not to issue any further selection or appointment letter to any other applicants under the new recruitment process unless the selection process of the petitioner is completed and appointment letter is issued. Any other relief, Your Lordship?
Yes, that is in aid of the present OA. You say that in the meantime there should be no a status quo. You're not seeking any relief in respect of the second recruitment process. That's precisely what we are asking you. How is that relevant today? That's not relevant. That was not relevant to you before the tribunal. So there are two things. One is the cancellation of the earlier recruitment process and the retest.
Yes.
They have given reasons which whether they can justify the cancellation or not, that is one aspect of the matter. The second is in the second recruitment process, you have not paid any relief in the second recruitment process. So what can be done in the second recruitment process? What is the order you expect us to pass with respect to the second recruitment process? You tell us.
Your Lordship, the retest was not, the result of retest was not declared and no ground was given.
Forget about retests. We are asking you about the second recruitment process advertisement of
Yes,
2012.
Yes, Your Lordship. The advertisement was identical with that of the previous.
But what is your relief?
Relief,
There is
Your
no
Lordship.
relief with respect to the second recruitment process.
Your
There is no relief claimed by you for the second recruitment process.
Lordship, since the first was subsequently declared to be vitiated, when I filed the application before the Honorable Tribunal, Your
Now,
Lordship.
by now, we have understood the entire timeline.
Yes, Your Lordship.
Again, we are asking you, just because you have approached the tribunal with an OA, that does not mean that whatever advertisements the department will issue, all will become subject matter of the OA.
No, Your Lordship.
So, if there is a process which you are agitating, a second process initiated, you say, so as to safeguard my rights, you keep a status quo in that. That does not bring the second advertisement in the fold of the OA.
It came, Your Lordship, in due course.
How can it? Unless there is a proper application saying that I have assailed this now.
Your Lordship,
cannot.
I cannot assail both the selection process at a time.
No, that is exactly what we are trying to say. How can you assail both at the same?
Not assailed.
So therefore, what is the, again we are asking, what do you expect from the court for the second recruitment process?
Yes, Your Lordship. I expect that since being a reserved category candidate, I was denied opportunity to get appointment in two recruitment process, Your Lordship, and I was found eligible by the same Ordnance Factory Board for Pune.
What is it you expect? Why are you repeating the same thing time and again?
I
What order do you think the tribunal could have passed in the nature of such a relief? You tell us.
Your Lordship, retest could have been conducted in a proper manner so that they could have been got the appointment, Your Lordship. If they had
retest was for the first recruitment process.
Yes.
We are asking you what is the second recruitment process. Regarding second recruitment process, what do you expect from the tribunal?
They could have given me the admit card for which I could have
For the
appeared.
second recruitment process,
yes.
without any prayer for that.
Prayer, Your Lordship, I came to know subsequently that they have vitiated
You came to know subsequently, came to know before the application was disposed by the tribunal. It's not that you came to know after the application was disposed of by the tribunal.
Your Lordship.
What effect, what steps did you take? You have not amended, you have not asked for any such relief. So therefore, any relief with respect to the
Your Lordship,
2012 advertisement is...
since 2018, two posts were kept vacant in 145 selection process, Your Lordship. So I never had the need to go for another prayer or
So therefore, you have not made any prayer for the second recruitment process. In order to ensure that your right with respect to the first recruitment process is reserved or protected, you have sought a status quo for one post, the tribunal has granted it, so that your pending application is not affected by the subsequent recruitment. Now, in this recruitment process, they have justified the cancellation. So therefore, what remains?
Oh, Your Lordship, in review, while hearing the
Review is over now.
review
Now we need not see the review.
the
We are looking at the tribunal's order. The review is over. So now you tell us.
Your Lordship, the respondents have not acted in the manner in which they had to act while conducting a new selection process. And I, being a candidate, when my mistake was nowhere, Your Lordship, I was allowed to sit in the retest. The court directed me to appear without prejudice to the rights and contents. But my
Does that
rights
mean everybody who sits in a test, they cannot be given an appointment? And every recruitment process that is carried on need not reach its conclusion. Many are vitiated, many are cancelled.
But my
It is your right that we are trying to see.
Yes,
Yes.
Your Lordship, but my application, my all thrice I was ignored, Your Lordship, by this respondent time and again when it was pending before the Honorable Court, Your Lordship.
Madam, some people appear 10 times. That does not vest any right in them to get an appointment. Thrice or 4 times, that's not the issue.
But
we are trying to understand what is it that you expect from the court. How the decision to find the recruitment process vitiated is not sustainable. That is the only thing to be seen, nothing else.
Your Lordship,
You have participated twice, thrice, interim order has been issued, all that. How does it matter? It is all in aid of the final relief. The final relief is whether the cancellation decision is justified or not.
Yes, sir.
That's all. So
Yes,
what is the infirmity in the decision?
Retest cancellation.
এটা কেন হতো ফাইনাল অর্ডার ফাইনাল এটা দিয়ে বার এটা বার
Not concerned with
Your Lordship, they had filed one affidavit wherein they had enclosed one document that cancellation of direct recruitment of 27 tradesmen. But throughout the proceedings, they always contended that I was not, I did not obtain or I did not, I was not successful in the retest, Your Lordship. So I was never been considered with a fair approach.
Madam, if the entire process is aborted, where is the question of considering anyone?
In retest, Your Lordship. In retest, I could have been come.
The retest result was published.
No, Your Lordship, I am deprived of this opportunity. And my mistake was that.
What happened in the retest? First tell us.
Retest,
You have been deprived, you have told us sufficient number of times. What happened in the retest, we are asking you.
It was cancelled, Your Lordship.
So therefore, we are saying once a process is cancelled, where is the question of considering anyone?
Your Lordship, they can.
It is not that others were appointed and you were not appointed. The second was also cancelled. Now, where is the cancellation of second?
This is the document.
Where is it? Tell us from the.
It's part of the review matter, my lord. We filed an affidavit because we made a oral submission based on a instruction. I made an oral submission before the Honorable Division Bench, my lord, in WPCT 1 and WPCT 2 that he has failed in the retest also. And it was that, my lord. Fact remains also that he did not succeed in the retest. It was his rank was 62nd. So when the Honorable Division Bench in the review matter, my lord, directed me to submit that on affidavit, that was submitted by me on affidavit, that even if he had succeeded in the retest, even if the retest results were declared, even if the retest was not cancelled, he would
Going
not have
to a hypothetical thing, where is the direct order cancelling the recruitment process? Just show us. Even if he had participated, how does it matter? He may have been the topper. If the result is cancelled, it is cancelled.
Yes, affidavit filed by the respondents, your lordship.
It was made. It was part of the. It was mentioned,
August
recorded in the order, my lord.
Order passed by the review court.
By the review court. Internal page 5, my lord, of the order passed by the Honorable Review Court, my lord. It says, my lord, that I had filed an affidavit annexing. Thank you.
Impossible. We can't consider anything like this. Impossible. You need to give us a compilation. Simply cannot be.
Your lordship, I may be given the liberty to file
Yes.
paper books, your lordship.
The learned advocate for the writ petitioner.
Number 10.
Item number 11.
Yes.
Lordship, in item number 11, I am led by Mr. Adit Chaubey due to personal difficulty and he is not available till 15th of September.
Huh?
Due to personal difficulty, is not available till 15th of September, Your Lordship. Till 15th of September.
The Lordship was previously pleased to direct both parties, my lord, to give just a brief list, my lord, of the points that we are relying on in each other's favor, my lord. So, my lord, this is the third occasion, my lord, when they are failed, my lord. My lord, I have prepared this list, my lord.
So you have succeeded before the tribunal.
Well, but part of my relief has been given, my lord. The part has not been granted.
What has not been granted?
My lord, the disability pension, my lord.
So you have also challenged the order.
No, no, my lord. It was not granted by the respondents, my lord. That was granted by the tribunal, my lord. I have succeeded before the tribunal, my lord. My lord, the respondents have challenged it, my lord.
What is the benefit granted?
My lord,
Disability element.
yes, my lord. Disability element in respect of one of my disability, which was held by the respondent as not attributable to service, my lord, the heart disease, my lord, which had generated after I had suffered the injury due to my ejecting from the plane, my lord, 8 years after ejecting from my plane, my lord, while I was serving as a trainer. That was allowed by the tribunal, my lord. And against that, my lord, the respondents union of
Yes, you were saying that there is a large batch of the cadets who you are training, and it was a very,
my lord, that I had submitted in page 37, my lord, paragraph 3.
it was a very strenuous job, and therefore
And
aggravated by.
yes, my lord. And the training vehicle, my lord, the training aircraft, my lord, that was an outdated aircraft that we had to train upon. That is the circumstance, my lord, leading to extreme stress and strain, my lord.
There is no interim order.
No, my lord. Interim order chilo ki? Na.
And we were required to see the Air Force entitlement rules.
My lord, your lordship is having all those things, my lord. Only the thing that I had referred and your lordship might not be having, my lord, is regulations for the medical services for the armed forces 2010. My lord, in the very subsequent case, my lord, I'm having a copy. I shall hand it over to your lordship. The rest, my lord, the documents I have already handed to your lordship. And my lord, the entitlement rules are same for all the three services, my lord.
Yes, take down. This is the third occasion.
Item number 12.
My lord, I am for the petitioner.
I'm for the respondent.
Petition has been filed challenging the order dated 6th August 2024, first by the Armed Forces Tribunal. My lord, in the way they have prayed that their discharge letter should be set aside, which was been the discharge letter. But at the time of passing the order, which will be relevant in the page 19, the honorable tribunal has stated that relief claim is disability pension. They have decided the case on the basis of the disability pension. All throughout the OA application, they have not even in the supplementary affidavit which they have filed, they have not stated about the disability pension they want. But at the time of hearing, they suddenly came to the point that they don't want to praise the other prayers. They want the prayer of disability pension, which was not dealt in the OA, not even in any part or supplementary affidavit which they have filed. Nothing but they has been decided. They have dealt with. They have prayed for it. Kindly come to the OA application, page number 46.
What the tribunal has done.
Come to the page number OA prayer. Prayer of the OA application which they have filed before the learned tribunal. They have sought for the relief of the discharge order dated 17th April 2017. To set aside the discharge order, and they have prayed for this thing. But in the supplementary affidavit, they also have not prayed for the disability pension or the invalid pension.
There is no prayer
No.
on the record whatsoever.
But at the time of hearing, which will be relevant in the page para 19 of the order, page 205, they have suddenly prayed for the disability pension, which is an alternative prayer. They don't want to press the.
But this alternative prayer, was it there in the OA?
No, there is not. Can you come to page 43, 44, 45, 46? There were not in the OA.
Page
43. Page 42 and 43 is the OA prayer. Set aside the discharge order dated 17th April 2017. They have prayed for. Now, an explanation for the concerned commanding officer why no relief is made against the representation of the applicant dated 29th April. They have not prayed for the disability pension. Not even in the supplementary affidavit they have prayed. They have stated.
Yes.
And the para 19 of the order, which are the learned advocate.
Yes, we have just seen it. In the course of hearing, he has made an alternative prayer.
Yes, page 205.
My lord, there is no doubt that the main OA, my lord, does not have any prayer in regard to disability pension. My lord, well, during the course of hearing, my lord,
Is it permissible? That is what we are asking. That we have seen.
my lord, the honorable
Without
court
any
has
prayer.
sought to modify the relief, my lord. Modification can be made, my lord, in pressing circumstances, my lord. The circumstance in this case, my
What
lord,
was the pressing circumstances which arose during
my
the
lord,
proceedings?
What happened, my lord, upon going through,
Which arose during the proceedings?
my lord,
What was the subsequent development?
my lord, no as such development, my lord. But
As such means?
my lord, upon going through the records of the
This is
case, my lord, upon going
what
through the
records? So
of
then
the case,
everything the court can do whatever it wants in any case.
modification of relief, my lord. The relief can
On
be
what basis? That is what we are asking you. Modification or alternative prayer? Where is that application? Show us.
no application was
Then-
made. No application, no doubt, my lord, no application was made, my lord. But the thing is that upon going through the records of the case, my lord, but upon going through the records of the case, my lord, it was found that this person was having disability. So, my lord, in any
Who
case,
found?
my lord, the learned court, my lord. The learned
Tribunal
court.
found.
Yes, my lord.
It is for the
That-
tribunal to find whether you have a disability or not.
That was on record, my lord.
You are here to sustain the order you have got. You have to say something.
My lord, may kindly come to page 17, my lord. It
Yes.
was ordered to them, my lord, to produce the release medical board.
Yes.
I had not produced, my lord. They had produced it, my lord. And upon going through the release medical board, it came to light that the prayer made by this applicant, my lord, for getting reinstated in service cannot be sustained, my lord. Upon
they have
such,
asked for the-
my lord, upon such circumstance, my lord, I had verbally prayed, my lord, to give me any alternative relief that may be granted, my lord. On that case, my lord, it was considered.
What is the date of the order? Passed
The
with?
order
On the 16th of August 2024, my lord.
6th August.
6th August, my lord. And my lord, this order, my lord, at page 17, my lord.
6th August
2020.
25.
4, my lord. Prior to that, my lord, another order was there. But the
He was
immediate
released because he was in low medical category
He was in low medical category, which will be found in the page number 57.
and he was getting any pension.
No, he was in the service. He was discharged from the service by a letter dated 12/5/2017, page 79.
well, this person was invalidated.
79.
Page 79. Challenging this letter he has filed this
12/5/17.
12/5/2007.
Use so many abbreviations that it's impossible to understand him.
Stated that 1577 Valmiki Journal of this subunit presently attached with your depot will be SOS from
Will be SOS means what?
Struck of strength.
Struck off the strength.
from Army with effect from 30th September 2017 and will report to the Army AD Center Depot
What is AD?
Air defense, my lord.
Air Defense Sentence on 7th September 2017 for discharge training.
So why this decision was taken?
Because he was placed in a low medical category.
Where?
Found in page 159. Sorry, my lord, page 57. Sorry, page 57. Page 57. January 2020, January 2015. Present disability 30%. He was kept in the service because after only if 15 years is for the pensionary benefit, he will get it. So he was kept in the sheltered position appointment.
He has completed 15 years.
Yes, he has completed. He joined in 2000.
So
He's been discharged from 2017.
So he will get his service pension, not disability pension.
He will get the service pension. He has not prayed for disability pension.
No, but when you discharge him on the basis of a low medical category, did you conduct the examination to ascertain whether he is suffering any disability?
This is a page 757. This is a
Page?
Page 57. We have done it. Medical board has been conducted and he has
30%.
30% disability.
So it will be broad-banded to 50%.
Yes.
So what is the consideration regarding it being attributable or aggravated by military service? Is there any consideration on this point?
We have not because he has not made any prayer to us, and moreover, it was not in the original application. So
we are trying to understand the system. Once one person is being discharged, then you conduct a release medical board. The release medical board finds a particular level of disability. So is it not in the procedure that the moment a disability is found, you have to come to a conclusion whether it is attributable and aggravated by service or not?
It is aggravated not by the service because it is by his fathers had this disease. It was a hereditary disease.
How do we know? And how do you know?
But it is written. There is written.
Yes. Where does it say not attributable and not aggravated?
Page 164. The relevant history. detected to have raised BP and
Madam, we are asking you, have you arrived at a conclusion that it is attributable and aggravated or not attributable and not aggravated?
it's not aggravated because of
Where is that conclusion?
he has come from here because his father had
We are not asking for inference. Where is the finding that it is not attributable and not aggravated? What instruction? Everything is here. What instruction you will take? Where is it in the release medical board? Show us. Where is the instruction required? The entire document is here.
stated in the affidavit in opposition also.
Stated in?
Affidavit in opposition.
Yes, let us.
Page 148. Para 3 4D. 4D. Number dash Valmiki Jadhav had high blood pressure, was referred to military, and on detailed examination he was placed in low and declared unfit for high altitude area. He was always in the sheltered position.
Where is it?
He has a hereditary history of hypertension. And he has not dealt with the affidavit in reply, he has not dealt with this paragraph. In affidavit in reply, he has not dealt with this paragraph.
So if the release medical board finds that it is not attributable and not aggravated, then what is the remedy available to the person?
Discharge from the service because he will be given to a sheltered position. The battalion he was moving towards the Srinagar, and Srinagar there is no sheltered apartment. So he was released up, and since there is
Such a finding by the release medical board, is it subject to any appeal? Such a finding by the release medical board, is it subject to any appeal? If the release medical board finds that it is not attributable and not aggravated by military service, what is the remedy to the person discharged?
page 182.
We are not asking you about sheltered appointment. We are asking you that if there is a finding in a release medical board that it is not attributable, not aggravated, does the person have any remedy in the department by making any appeal or anything?
No, my lord, because it is, I am coming to the rules regarding the discharge of regarding the disposal of a fundamental low medical category. These rules have been annexed in page 181. I'm coming to that rules.
Yes, you must be knowing. What is the remedy?
Lord, a first appeal and a second appeal.
It has to be. You are appearing for the organization, you don't know. You are taking us here and there unnecessarily. Only when he fails in all that, then he comes to the tribunal. We have seen in so many cases. You're taking us through unnecessary documents. And when there is a finding that it is not attributable, how, without going through the appeal process, he can approach the tribunal? There is a finding at page 60 in the release medical board, not attributable.
The release medical board has not been attached, my lord, to the in any proceeding, my lord, before the tribunal. It was produced in original, my lord. My lord,
Because you did not challenge anything. Where is the
my lord,
question?
upon an order by the tribunal, my lord, it was produced.
So
My lord.
if
These are
you-
the two copies.
Not required. We don't want to add anything to the documents.
My lord, one more thing, my
Come
lord.
to page 60.
60. Yes, madam. These are the grounds for denying disability pension. That is the onset in peace. This is the only ground. And this
Is the disability attributable to service? No.
no, madam.
Is it aggravated? No.
No, madam.
So both are no.
My lord, both are no, my lord. Nana case, my lord.
Then you
So, my
challenge.
lord, the one thing, my lord, the grounds on which these
We
are
don't know. We are not going to go into the grounds. Take down. Come.
grieved by the denial of entitlement.
It does not say that a rejection has to be communicated.
My lord, if a rejection
And there is already a denial here. It is saying not attributable and not
that
exhibit.
has to be communicated to me, my lord.
Where is that, sir?
My lord, I can show your lordship, my lord, at least 100 such documents, my lord, in each and every cases.
Yes.
My lord, where this has been communicated, my lord.
Everywhere we have seen, that after this finding, they dispute it.
My lord,
That why you have held not attributable, not aggravated.
Yes, my lord. That is communicated to me by the record office saying that your disability pension claim has been rejected.
Claim. So where is your claim? That's what we are asking
That
you.
is a procedural aspect, my lord.
There it becomes a procedural. And for them it becomes obligatory.
But I am very sorry to.
We are not going to enter into that. That is not the subject of the OA also.
It comes on the discharge procedure, my lord.
We don't know.
My lord, then kindly grant me one time, my lord. I shall come back.
We are not going to enter into that. You challenge it as you would like, in accordance
I
with.
have to challenge the particular rejection, my lord. Where is the rejection letter, my lord?
But you have proceeded in this way before the tribunal. You will have this problem.
My lord, now that your lordship is directing me to file a first appeal, it has to be.
We are not directing you. We are allowing you liberty to file. Why should we direct you?
My lord, for exercising that liberty, there has to be a rejection.
Then you ask them for a rejection. Who is stopping you? You can ask them.
That has
Yes,
never
take
been
down. What is?
communicated, my lord.
Yes. What is the last?
'28, page 57.
Just have a look.
matlab the release.
It's 28th.
কবে মেডিকেল কবে বসানো হয়েছিল না লো মেডিকেল ক্যাটাগরি
That matlab
it was placed in the low medical category. I wrongly mentioned it was 8 January, it will be 28
We saw 8. 2 was not visible.
ওটা শেষে না 8.
25th.
So it is 25th January, matlab.
Yes.
57.
Correct. 25th January.
That small indulgence, matlab, would have helped me.
For the next.
Grateful.
Item number 20.
To appear for the Petitioner Union of India. My lord, the respondent is not, I am absolutely prepared with the matter, but respondent is not here. And today there is a resolution. But
There is no resolution today.
there is a resolution, not to.
This one. Nobody has communicated any resolution. Has come.
My lord, I am prepared with the matter, and on the
Then if there is a resolution, if one party is not there, then
one aspect I beg to place before Lordship. On the last occasion, your
not today, not today. Call the next.
Well, my lord, on no occasion the respondents have appeared.
Call the next.
In this, in that even, my lord, if your Lordship kindly keeps it tomorrow at 2, my lord.
Call the next.
Item number 27.
What was the resolution? Oh.
Tribunal has proceeded on the basis of.
What is the normal in view of such a resolution? What happens in the other courts? Yes. Yes. What is it? Let us see.
185 of half paragraph. My case was very specific, that at some point of time they have admitted themselves admitted a particular case on a particular case. If you listen to the last paragraph of page 185, the matter relating to fixation of linearity is not a matter as claimed by the applicant. For subject matter of series of litigation which is finally settled by the Supreme Court in the case of money. Ordered at 7/9/93 passed by the division bench. Of the Honorable Court and civil rule number was dismissed. The applicant is now allowed liberty to pursue any remedy which may be available to him or related to fixation of his pay on the part of UDA. Thereafter, the applicant filed an application OA before this tribunal under Rule 54, which was dismissed on contest. Where there was no subsequently applicant put this before the Honorable Court, same matter in the PST which was dismissed by judgment day 18/8/2001. The dispute between the parties related to seniority of the applicant and the matters related to subsequent pay fixation have reached finality in judicial proceeding. In the application, fairly barred by the principle of res judicata and fails on that ground. Cited with different infractions of no the act. Also, calculations were not submitted by the respondent. The application did not count the wrong submission. Calculation has been admitted by the applicant, creating weak ground of error. The only point that this question is recovery of output that My argument is specifically on this point. My prayer was not based on my seniority or on the pay of my juniors. It was a very simple claim, my lord, that at certain point of time you have admitted you can't be this. At best, my lord, at best, the learned tribunal could have read that it was part by principle constructive res judicata.
Where is the prayer in the way?
Page 1. Here again, it has been granted. Can be a same prayers, my lord.
So this 2070 as on 1591. According to you, this they have themselves calculated. Where have they made this representation? Where is that?
Page 71. Page 71. First, my lord, to the final calculations, second paragraph, my lord. Now, I'll kindly to page 25. The second paragraph at the bottom, even on the basis of the final calculation. Start with page 75. Bottom part, my lord. Even on the basis of final calculation which is submitted on the last date of hearing by the respondent, we find that the respondent have not fixed the petitioner basic pay correctly and have thereby failed to confer the consequential benefits on the petitioner till today. According to the final calculation which they had submitted, my lord. According to the final calculation which was referred in page 71, made up to 1599, his basic pay as on 1591 was 2070. Now the honorable court moves on to subsequent why he should get higher pay. this may be compared with the basic who had 6. They are not denying me this pay scale. They are denying a higher pay scale.
So this order was set aside.
Kindly see page 46. This was the direction passed.
This order starts from which page? 40, 46.
Page 59.
59, 60.
No, man. There is a discrepancy in your lordship's record, my lord.
60.
Possibly after 61. 61, possibly there is some mistake.
Oh.
No, 60, page 60. Page 60 is possibly before.
দেখুন ভুল আছে
This is order of 7993.
Yes.
Passed in CR 2650.
2650 is a contempt.
অর্ডারটা কোথায় পাস হয়েছে বলছেন?
This is by the lead court.
এটাই
No,
জানতে
no,
চাই।
appellate court.
রিড কোড, দিস ইজ বাই দ্য
Lead court.
আপনি পেজ 60 দেখুন। এটা কোথায় পেজ 25? ও আচ্ছা আচ্ছা। হ্যাঁ ঠিকই ঠিকই।
And this has been interfered with by which order?
By my lord.
Contempt.
ওটা নাম্বার না order dated 9th February 1995 at page 82.
95 Supreme Court 1359.
Yes, my lord.
7 September 1993.
9 February 19.
No,
This has been reported in 95 Supreme Court 13.
Yes, my lord.
page 82. That which is that it is the order dated 7 September 1993.
Date, order date.
Order date is 9 February 1995. 9 February 95.
What has been done?
Here also, my lord, in paragraph 9, it has been recorded, but it has been recorded as my submission.
Yes, there is no determination of this amount. It was an amount which came up in the course of a proceeding.
This is my only claim, my lord. If I am to get anything benefit, I am deriving my right only from that, my lord. I do not
Yeah.
contest anything, my lord.
Therefore, how can you, unless,
Because this is the amount they admitted before a court.
no, they didn't.
They submitted a chart.
Where is the admission? It says that one chart has been submitted.
Yes, my lord.
When they say this is a,
Court was repeatedly giving them an opportunity.
that was a ongoing process. No determination was ever made.
But they said placed that chart before again saying
Yes,
that
they have. We have seen it.
Yes,
But
but
the
that-
court
that-
has rejected it.
it has.
Court has rejected it. So court has found it to be unsustainable.
The court has found, but this is my limited case. But the court has said that this amount is not unsustainable because he's supposed to get a higher pay. My case is simply on the basis that if you at one point of
What are you getting right now?
the scale, my lord. I'm not very sure, my lord, of exact scale.
He has already retired.
Obviously. His claim is for pension.
I think lower than this. Obviously.
What are you getting? That's why we are asking you. You say X amount was thrown by them in a proceeding. At least give me that.
Yes.
So what are you getting if you are not getting X? And from where we can gather this fact?
Their opposition.
And this order, this is against which order? Let us see. Maybe it is recorded in the order. What you are getting at the moment.
That is
Tribunal's order.
This is 178, my lord, page 79, 2010. You take it? No.
960 of 2003.
Mine. Let's shoot this notice. This is a page 151. 151. Legal notice which I had issued.
You have mentioned there what you are getting.
Yes, sir, at page 154. I have not mentioned the initial amount, but at present, this as on 9th July, I had stated that following opposite calculation, my client BC at the time of retirement should have been 8675 and the pension should have been 4338. However, my client is only getting 3775 as pension at present. Also there in my OA, my lord. In the OA I had filed, my lord, at page 103 it is also there. Paragraph paragraph 90. 690. Paragraph 690.
619.
Same. At page 162, my lord, is their reply to my paragraph.
Calculation sheet at page 165.
Calculation sheet. This calculation sheet matter the diverted the matter, my lord, from the real.
তাহলে 70, তাহলে কত 2012 সালে 70, এখন কত হবে? টিচার 2012 সালে
বেঁচে আছে।
না,
ক্যান্সার
2012
ক্যান্সার।
না 2012 সালে
বেঁচে আছে।
না 2012 সালে 70 হলে এখন কত হয়? 12 আর 10 এ 22, 12 10 এ 22, 22 তিন তাহলে কত হয়? 10 3 13
83
করেছি ভাই।
আমার বাবাও তো 84 ক্যান্সার হয়েছে হাসপাতালে।
Yes, you are saying which page?
I was showing one more page.
Yes.
Reply to my, their reply starts at 156. Your lordship kindly see 162. Bottom of the
This reply filed by them.
for the tribunal.
Yes. Paragraph?
Last paragraph, paragraph 8. With reference to a statement made in paragraphs 617 to 623, my specific allegation was 619. I deny and dispute all the contents of the applicant, save and except water matters in this regard. I state that all pension have been taken to the applicant have been taken to the applicant to accordance with the laws. In this case, repeat and write. Nothing more.
And where is that calculation that you are relying upon?
calculation chart, my lord. And I am not.
We have given that page 160.
ওইটা কোন আপনাদেরটা না, আমি যেটাতে রিলাই করেছি। There are two calculation, one given by them, my lord.
In those proceedings.
Yes, my lord. I
Contempt
had
rule.
given a chart.
No, in contempt rule proceeding, they had given the chart.
No, that is not on record, my lord. That chart is not on record. So my client had given me a chart. I had submitted that chart because time to time several charts had been filed. So during.
Therefore, we are saying, you say that in the course of the contempt rule proceeding, they have given a chart
Right.
where the calculation comes to 2090, and that should be taken as the basic pay from the date of joining.
Right.
Now, where is that chart?
168 got the chart. Another chart, final calculation.
168.
160.
168 chart given by us.
That is charge given by you.
In the original application. In the original application.
According to this, it comes to 1671 instead of 2090.
Now 168 card charge.
Take last portion.
So that is in my favor. 15/1992/2070. It's 168 is in my favor, my lord. So I should be very careful, my lord. 168, absolutely bottom, my lord.
2070.
2070.
So this has been submitted by you.
Yes. In that
Then give it to him. Then you give it to him.
That chapter closed because after the order passed by the division bench, then.
No, this has been submitted by you.
Yes.
In the OA.
In the way, that's the
reply part. Reply, my lord. This is a part of the reply, my lord.
part of the reply.
So if a due is found admissible by him, then why should you resist? That we are trying to understand.
He wanted benefit under Rule 55(4). Then matter went up to Supreme Court. Order of the division bench was set aside. Then he filed an original application.
No, that did not go up to the Supreme Court. The compliance went up to the Supreme. That issue did not travel to the Supreme. So he wanted a particular benefit. You calculated it in a particular manner. He said, no, it should be otherwise. The apex court said, this is not an issue for contempt. You go and agitate it in a proper proceeding. Now, in the proper proceeding, if you find that he is entitled to this, then why are you resisting?
No, but kindly see the page 204. While after disposal of the can application by the High Court, he filed an application for clarification of the order passed by the High Court. Page 204, middle portion.
No. We are not on that. If
totally no issue.
If the admitted position is that you are calculating his due to be 2070, forget about what was produced in the 93 proceeding. In the 93 writ proceeding, which calculation chart was produced? Forget about it. In this way, you have held that this is a calculation. Then why you are resisting the payment? And you did not show the tribunal that here also they are giving the same calculation.
Problem was a direct accusation was when I was myself appearing and I was very much junior at that time. A direct accusation was made that I am trying to mislead the court, and that was the only matter which was discussed. I admitted that these pages don't tally. There must be. I could not argue on any other point. It was direct allegation that I was making this manipulations in the chart.
This is part of your reply.
Part of their reply.
When I kindly see page 156, reply starts. And 156. Reply by the respondent.
All right, I will go through this. Tomorrow we'll pass the order.
And my lord, one more thing, my lord, in spite of giving this proceeding, my lord, they were granted an opportunity to file an opposition. Opposition was not filed in this proceeding, my lord.
In which proceeding?
Proceeding, my lord. In before your lordships.
In this writ proceeding.
There was an order, my lord, directing them to file affidavit in opposition. They did not file.
So they had their reply is there on record, not required. Whatever stand they have taken in the reply, they will be bound by that. What is it now? You want them to file a opposition?
No, no. It goes against them that they have not.
How it will go against them, sir? They have placed their entire matter on the record by filing a reply. So that will have to be considered. In fact, usually I don't allow them to file if they have already filed. Only if in some cases where without opposition it has been disposed of, then I allow them to file. Otherwise,
We
why
have filed a reply before the tribunal.
Yes, then why should they send this file?
My lord, next matter is ours. Other side is here, my lord. I have, my lord, served the copy of the reply. Today.
So, my lord, we both are, my lord, praying before your lordship, if a date may be fixed for hearing, my lord, after 12, my lord, any date. Number 28?
Yes, I am for the petitioner.
I am for the respondent. There was a direction of affidavits. My lord, after 12th, any date, man, convenient to your lordship. Any date. That side of the vacation, as pleases your lordship.
Yes,
Reply to
I am
file
filing
the-
it.
I have filed the opposition. I have served.
Yes, I am filing the reply, my lord.
Service to the-